All right, everyone, we are going to go ahead and get started. Thank you for bearing with me. I had a slight delay due to technical difficulties. But welcome to this Work from Home Wednesday session on forum shopping. All of you bear with me just one moment. Make sure we have everything. All right. I think we're all now set. Okay. So if for any reason you start to experience audio issues, please let me know by typing a message into the chat box of GoToWebinar. I apologize once more for this clunky start. Technology and myself were not friends today. So what we're going to talk about today is really the law and public policy around forum shopping. Now, before we dive in, as always, this webinar is designed for information purposes only and does not qualify for CLE credit. If you need credit, we always have a consistent library of CLE webinars available for you by going to fastcase.com/webinars. So with that being said, let's dive right in. So how do we define forum shopping? Now, I will tell you, like a lot of areas of law, the definition of forum shopping really varies jurisdiction by jurisdiction and sometimes judge by judge. I think for most purposes, a general good definition of forum shopping would be the one that we get from this law dictionary, which is the practice by both parties in litigation of seeking to bring a claim or transfer an action to the forum a litigant believes is the most likely to favor its own argument. Now, this being said, we forum shop for a myriad of reasons: to get better substantive law, to get better rules of procedure, to avoid our legal actions being barred by forums that have less than lengthy statute of limitations. We also do it for things like efficiency. So would it be expensive if I moved a legal action into one forum versus another if I need to do things like gather evidence? We also look at things like location of witnesses, things of that nature. We're going to talk about all of those in detail. So really we'll go ahead and get this out of the way. What is the most important factor in forum shopping? Ironically, the most important factor in forum shopping is going to be jurisdiction, jurisdiction, jurisdiction. Now, you are probably thinking to yourself, well, that's common sense. If I don't satisfy the jurisdictional rules, if I don't satisfy the venue rules of the forum where I desire to bring a legal action, of course, I can't bring it. Well, despite that being common sense, we also know that unless a jurisdictional requirement is provided by a state statute or by an act of Congress, judges do have equitable ability to waive certain jurisdictional requirements. So I point out that making sure that we have jurisdiction and that we meet the venue requirements is really the most important factor in whatever forum we are seeking to file legal action, because judges will not, and I repeat this, will not engage in the waiver of jurisdictional and or venue requirements, even if they can, when judges have determined that the reason for, or the reason you are seeking said waiver is to forum shop. Whether that is right or wrong, good or bad, that is based upon me surveying every jurisdiction that talks about, or that has a decent amount of forum shopping cases within those jurisdictions. That is, you can almost make that a bright line rule. Why that is, we do not know, but we know that in hundreds of other circumstances, judges will waive certain jurisdictional and venue requirements. If they think your motivation is forum shopping, they will not. So we really have 5 types of forum shopping, and we're going to talk about those in a list type format. So the basic one is choices involving federal court versus state courts. So we know from doing any type of litigation that there are some type of cases, for example, that are restricted solely to state courts or solely to federal courts. One example would be divorce actions. Federal courts often do not and will not allow you to entertain a divorce proceeding in federal court. We also have things like patent litigation, which must be filed in federal courts. Now, the thing to know about this first type of forum shopping is we want to check for exclusivity. Now, if Congress or if the Constitution has not allocated a category of legal actions to a federal court or to a state court, then this is one area where we can entertain the aspect of forum shopping. So we really think about this as issues around concurrent jurisdiction. And we'll talk about in a moment, there's only one example where the Supreme Court does not encourage concurrent jurisdiction, but otherwise across the board, Supreme Court jurisprudence really gives us immense amounts of flexibility to choose between federal courts versus state courts, except when issues of federalism arise, which we'll talk about in just a moment. Now, this, of course, is the other obvious kicker will be that, as we talked about a couple of slides ago, you still have to be able to satisfy subject matter jurisdiction, personal jurisdiction, and venue in whatever federal court or state court you wish to bring your legal action. This will be an example of, as we talked about before, there are areas where states tend to have exclusive jurisdiction. These tend to be domestic relations and issues around probate. Now, the Second Circuit recently revisited the aspect of whether or not federal courts were becoming more and more inclined to entertain probate matters, and the result from the Second Circuit Court of Appeals was to sort of maintain the status quo, was to continue recognizing that for the most part, unless we're dealing with issues of taxes, that state courts maintain exclusive jurisdiction over probate matters. And then, of course, the other common one that we may remember from law school is that federal courts do not like to get involved in matters of the heart, as Justice Scalia once said. So, for example, as I was noted earlier, they tend to not, in federal courts, want to grant divorces, deal with alimony, settle things like custody of children, and things of that nature. This is also relevant because they believe that for whatever reason that issues around family relations are a matter of state policy. I went out and tried to find the basis for why this is, why people say that things like family relations, at least as it pertains to custody, alimony, and divorce, are considered to be just a matter of state policy, and I could not find a solid rationale except the fact that federal courts say that it should be. So this is, of course, is the statute talking about the fact that federal courts have exclusive jurisdiction over patents. Just an example of where we see that this sort of federal exclusive jurisdiction. We also will know that other areas where federal courts tend to have exclusive jurisdiction, thereby not allowing for forum shopping in those areas, will be copyright matters, issues involving the military, immigration matters, and bankruptcy proceedings. I've also found you a couple of charts that I really enjoy that sort of lay out broad categories of when states or when federal courts tend to have exclusive jurisdiction. As we know, when we're dealing with issues of concurrent jurisdiction, most likely those are going to be in matters where we are gaining jurisdiction based upon federal diversity. So use these charts. I found them to be the two areas or the two charts that were the most useful when sort of remembering the broad categories when I'm trying to find an appropriate forum. We also, as I noted before, because the most important thing to know about forum shopping is to be able to know when you have jurisdiction for both personal and subject matter, and also know when venue requirements are being met. These are two more lovely graphs for you. I really like the one on the right. It's kind of a nice entertaining version of civil procedure. And on the left-hand side, of course, we have a nice chart that you may have remembered from a civil procedure exam in law school. I also, and by the way, I will be sending you out these slides, so you will have these graphics for your own personal use. I also have provided for you just a nice layout of the process for determining subject matter jurisdiction. Now, I will say, all in all, from these charts, the big takeaway to remember is, as I was noting before, while courts sometimes can and will waive jurisdiction requirements, and of course this is absent ones that are provided by a federal or state statute, I could not personally locate a single case where a court would even remotely consider waiving any of these requirements for the purpose of forum shopping. What was made clear in a review of the various cases around this matter is that judges do not only want to make sure that you meet jurisdictional and venue requirements, they also want you to argue to the court in a way that is crystal clear that you meet the jurisdictional and venue requirements for the forum that you are in and or the forum that you are seeking transfer to. So just keep that in mind. Now we have our second broad category, which is going to be forum shopping when we have choices involving courts in different states. Now this area of forum shopping is most effective when you can meet the jurisdictional requirements and the venue requirements, and you are also seeking favorable court procedures or favorable court rules, and not when you are seeking a more favorable substantive law. So when you are forum shopping between state courts, you are most successful when you are dealing with, at times, you're dealing with two states that may have similar substantive law, but that may have different procedural or court rules. So keep that in mind. Now, it is not impossible to be able to be moved to a state court from another state court just because the other state court has more favorable substantive law. However, it is not highly encouraged. Then we have our third category, which is kind of a breakaway of the one we just talked about. So this really is the classic forum shopping paradigm. Now this, unfortunately, is also the one that raises the most negative opinion. People tend to call forum shopping for the purpose of seeking a more favorable substantive law. They call it, judges have called it unfair, they've called it devious, they've called it impermissible. However, it is important to also note that choices involving different substantive laws do not, and I repeat, do not raise uniform concerns and are not uniformly, and this is important to note, uniformly impermissible. So for that, we really go to Erie Railroad v. Tompkins. So this was a case that was concerning the potential for applying different substantive law as between a federal court and a state court located in the same state. Now, this Supreme Court case led the Supreme Court to require federal courts in diversity cases to apply the substantive law of the state in which they sit. Now, the important thing to note is that the Supreme Court in this case has only condemned, and I repeat, has only condemned forum shopping in the narrow context presented by the Eerie case. And that narrow context is in order to prevent different results within the same state due to the application of different substantive law as between a state court and a federal court located within that state. Now, the Supreme Court has never, and I do repeat, has never prohibited choices involving different substantive laws beyond the narrow Eerie concept or in situations where Congress has not spoken to explicitly limit jurisdiction. And therefore, at least based upon Supreme Court jurisprudence, differences in the substantive law remain a valid form of forum shopping. So just keep that in mind. If people tell you that Erie Railroad really barred the ability to seek out favorable substantive law, that is not true. It applied in a very narrow example. So the type 4 is, of course, the other broad category when we are seeking favorable procedural variations. So we may look at things like, okay, differences between states in statutes, rules, local rules, evidence provisions, things of that nature. We may also, and another way that people have attended or have successfully forum shopped is arguing that a court system or that a specific judge is more familiar with procedural rules or court rules in specific forums. People have also successfully argued the flip side of that, that a lawyer, so let's assume that a lawyer is licensed in multiple jurisdictions, people have allowed forum shopping in events where a lawyer has successfully argued that the basis for their forum shopping is that they are more familiar with one set of procedural rules than with another. And then last but not least, we have what I call the catch-all category. This is going to be choices involving subjective and personal factors. So for this category, people argue things like, you know, where is a lawyer licensed to practice? They'll argue the reputation of judges. They will look at things like, will I have a more favorable jury pool in one forum versus another? They look at things like previous jury awards. They also look at things like access to witnesses and access to the various parties. Things of that nature. They may also take into account, people have even successfully argued forum shopping on the grounds of political climate and bias. So for example, people have argued that in specific jurisdictions, they, based upon political outlook, are more favorable to defendants than plaintiffs and vice versa. So going back to I briefly spoke about the Erie case, let's dive into a little bit more about what the Supreme Court says about forum shopping. So to dive a little more into detail about Erie, Erie was a case where we had an individual who claimed that he was injured and permanently disabled by negligence of the Erie Railroad Company. So Tompkins claimed that he was walking home late at night on a footpath that was running parallel to railroad tracks. And all of a sudden he was struck by something that looked like it was a door projecting from one of the moving cars on the train. Now, it is important to note that Tompkins was a Pennsylvania citizen and that the accident occurred in Pennsylvania. Now, in this case, the Pennsylvania law would have precluded any recovery because under the law of Pennsylvania, persons who use the pathways along the railroad right-of-way are deemed to be trespassers, and therefore the railroad would not have been liable for injuries resulting from its negligence unless the railroad was engaging in willful negligence. Now, Tompkins said, okay, well, this is not an ideal outcome for me, so he sought out legal action in another forum. In this case, he went to the Southern District of New York. Now, Erie Railroad was incorporated in New York, so we had federal subject matter jurisdiction on the basis of diversity. Now, it is important to note that in this case, that the court essentially said that in order to prevent us from having a federal court in a state interpret state substantive law one way in its court, and then to have a state court up the block interpret that same state substantive law in a different way, was not ideal. They said that it really affected two things. It affected the state's right of sort of territorial sovereignty. It also affected the state's ability to administer its own laws. Now, it is important to note that for many a legal commentary, or many a legal scholar or commentator, including myself, that Erie is often interpreted very narrowly. So if we look at another Supreme Court case, Guaranteed Trust v. York, we really, and this is also a subsequent Supreme Court case, we really are able to understand what the narrow interpretation of Erie would look like. So in Guaranteed Trust versus York, the court said the following. In essence, the intent of the Erie decision was to ensure that in all cases where a federal court is exercising jurisdiction solely because of the diversity of citizenship of the party, the outcome of the litigation in the federal court should be substantially the same, so far as legal rules determine the outcome of litigation. So really, the walkaway of this statement is that for the same transaction, in this case, the accident of a suit by a non-resident litigant in a federal court instead of a state court a block away should not lead to a substantially different result. In short, Erie only discouraged forum shopping in circumstances where you are choosing between a state or federal court in the same state. To allow otherwise would be to disrupt the uniform administration of the law within a single state. So the point of this is that Erie is recognized by some who do not favor forum shopping as kind of being this broad ban on all practices of forum shopping across the board, when in fact the Supreme Court itself has said, no, we actually read Erie much more narrowly. So the giant takeaway is, okay, well, ultimately, how does the Supreme Court today feel about forum shopping? So I tell people to ask yourself one question. Does your legal issue involve a transfer of venue from one forum to another under 28 U.S.C. section 1404A with the expectation that the substantive law of the new state will apply? If not, then Supreme Court jurisdiction does not frown upon forum shopping. In fact, the Supreme Court has upheld the practice of shopping among states for the forum with the most generous statute of limitations, for example, on multiple occasions. So notably, if we looked at the case of Keaton versus Hustler magazine, in this case, Kathy Keaton, a New York resident, had sued Hustler magazine for libel in a federal district court in New Hampshire. Now, you may ask, why did Kathy Keaton sue in New Hampshire? The reason being is that her legal claim was barred by the statute of limitations in every other state. Now, the court, at the end of all this, noted that despite the fact that it was barred in every other state in the country at this point, except New Hampshire, that her lawsuit was valid. The court ultimately said that petitioner's successful search for a state with a lengthy statute of limitations is no different from the litigation strategy of countless plaintiffs who seek a forum, and this last part is important to note, who seek a forum with favorable substantive or procedural rules or sympathetic local populations. So the Supreme Court has not even explicitly banned forum shopping, but based upon the Keaton versus Hustler case, has recognized it as a valid litigatory practice. So with kind of the layout, with the taxonomy, with things of that nature out of the way, let's talk about some best practices for forum shopping. Number one, location matters. If you attempt to file your suit in Illinois, Arkansas, New York, or Georgia, you may not be successful if your basis for filing in those states are on the grounds of forum shopping. In those areas, they, as a matter of public policy, not only discourage forum shopping, but appear to, in most circumstances, outright ban it. A way to know if your jurisdiction, if the state in which you are seeking to forum shop encourages or discourages forum shopping, you would want to run the search. I would put forum shopping in quotations, and then I would add to my query judge shopping. What I have was able to unearth when I was looking at the various jurisdictions that discourage forum shopping is that when they are talking about how much they dislike forum shopping, they often will call forum shopping sort of disdainful because they call it a matter of just judge shopping. So if you run your search that way, it will get you the results that you need. If you ever have some time, go and just read cases in Georgia, and I'll provide you with a couple of those cases talking about the idea of judge shopping, because a state court judge in Georgia does not have time for the notion of forum shopping. Then, of course, this is just some excerpts from various jurisdictions that appear to frown upon forum shopping. So here we can see that in Arkansas, that they say it's something they have not chosen to encourage. In the top left, we have our case law from Georgia, where they talk about this is a case of foiled judge shopping. And then, of course, we also have our various case law from parts of California that tend to follow the New York direction, which is basically, we don't ban forum shopping, but we highly discourage it. They explicitly in California really discourage forum shopping when criminal law matters or habeas corpus matters are involved. Another best practice, forum shopping by judge recusal rarely, if ever, works. So there are a number of cases out there where people try to get a more favorable outcome for their case by arguing that a judge should recuse themselves on a number of many different grounds. They will say that a judge should recuse themselves because they have bias, or because they are mean to the plaintiff, or because they do not understand the law, because the plaintiff is not fond of the judge's legal opinions. People have tried many a practice to forum shop by judicial recusal. It never works. I repeat, it never works. The most common way that people tend to look at recusal of judges is under 28 U.S.C. section 455, which says that a judge should disqualify himself in any proceeding in which his impartiality might reasonably be considered. It also says that a judge should disqualify himself if he has a personal bias or prejudice against a party or against the evidentiary facts concerning a proceeding. Now, for states that have provided their own version of recusal statutes, they tend to just mirror what is provided in 28 U.S.C. 455A. Now, it is important to note that despite this being a valid form or grounds for a judge to recuse themselves, recusal is never granted if the forum where you are filing the motion to recuse gathers any odor, and I repeat, any odor that you may be filing this motion for recusal in order to get a better judge or in order to get a more favorable outcome, things of that nature. You have to clearly establish things like bias and impartiality without even remotely suggesting that you are forum shopping. You may be forum shopping, but do not suggest it, because that is the quickest way to get your recusal motion thrown out in state or federal court. Oh, do not recuse, do not base your motion of recusal by threatening to kill a judge. Now, this is one of those areas where you would think that I thought I would never have to say this. However, reviewing recusal case law that involved discussions of forum shopping, I found no less than 11 jurisdictions, 7 federal and 4 states, where people had attempted to get a more favorable judge by threatening the judge generally with acts of violence, or by going further and threatening to kill the judge if the judge did not recuse himself. So basically, do not do that. Now, the states you see on your screen represent the fact that in 50% of all state courts explicitly have noted they will not allow forum shopping when the method of forum shopping is via a motion to recuse a judge. Now, what is interesting about these jurisdictions is that the courts did not allow the motion to recuse or did not make a judge recuse himself, even when, in addition to motivations around forum shopping, the person moving for the motion to recuse also had valid evidence of judicial bias, of judicial impartiality, et cetera, et cetera. So even if you are forum shopping, just don't let the courts know. I guess is what it appears to be the takeaway from this. Because if there is an odor that you are using recusal in order to forum shop, even with valid evidence of, bias, things of that nature, they will still throw out your motion for recusal. Now, statute of limitations. So with statute of limitations, if the only basis for your forum shopping is that one jurisdiction has a better statute of limitations than another, then courts in the majority of all states have recognized this as a permissible form of forum shopping. Now, the reason being is that for the courts that allow this, is they say, okay, well, because substantive law typically transfers from the originating forum or your home forum, that a defendant will not be unfairly burdened by forum shopping based upon a more favorable statute of limitations. Because as we may also know from case law, statute of limitations is not recognized as a piece of substantive law. It is recognized as a procedural rule. And this is an excerpt from a case that really lays that out for you. They tell us that the common law rule governing choice of the applicable statute of limitations is that the forum normally applies its own statutes of limitations to actions before it for various reasons. Now, if we read further, we also know from this case that a plaintiff can choose a forum with a longer statute of limitations, and that this the common law rule precludes a uniform limitations period for a particular cause of action and encourages forum shopping. Now, we may also remember from the Hustler case that also involved a case where an individual was seeking a more favorable statute of limitations in order to not have their legal actions barred. So if it's good enough for the Supreme Court, it's good enough for me. Now, what is also interesting is that the idea that one can forum shop in sort of the most successful manner if they're looking for more favorable procedures versus more favorable substantive law is based upon this other excerpt from a case, and that is talking about the fact that even when we're dealing with forum shopping between a federal and a state court, if the federal procedural rules and the state procedural rules will provide a different outcome, that is still a valid form of forum shopping. And this is from the case Madison v. Dallas Carrier Court, and I will provide you with that case in my follow-up email. Now, if you are forum shopping based upon things like, or based upon a statute of limitation or other sort of time-sensitive procedural grounds, make sure you check to see if your state court has a borrowing statute. Now, the rules, because the common law rule that the final forum always applies the rule of procedure applicable to that forum has an exception, and the only exception is when that state has a borrowing statute. So what is a borrowing statute? A borrowing statute is a legislative exception for the general rule that the forum always applies its statute of limitations. Now, they do vary somewhat, but they all provide that the forum state, if a borrowing statute is present, this means now that the forum state will apply the statute of limitations from the foreign jurisdiction in which the cause of action originated. So this would mean that if we look at an example, let's say for, this would be Kentucky. So if we were looking at the borrowing statute from Kentucky, if you were injured in Tennessee and you were attempting to file your action in Kentucky because Kentucky you thought had better rules of procedure, Kentucky has a borrowing statute, so they would say, no, no, no. We can still hear your case, but we're going to apply both the substantive law and the rules of procedure from Tennessee. So make sure you check to see if the jurisdiction where you're forum shopping has a borrowing statute, because this can really affect the outcome of your case in the event that it is barred in the originating jurisdiction. Now, as most things we know, borrowing statutes also have an exception to an exception, an exception to an exception. So one might think that the borrowing statute would destroy all chances of forum shopping based upon rules of procedure in another forum. However, that is not entirely true. For example, in Florida, we say that borrowing statute aside, the courts apply the rules of procedure for the forum that has the most significant relationship to the injury seeking to be redressed. I repeat, in areas in places such as Florida that has a borrowing statute, the courts still apply the rules of procedure for the forum that has the most significant relationship to the injury seeking to be redressed. Now, in places like Kentucky, we have the final act rule. So in places like Kentucky, they have a borrowing statute. However, they say that we follow the rules of the procedure for the forum where the final act of the injury occurred. So if you had a tort claim, if you fell in a flight of stairs in Tennessee, and that was the final place where your injury occurred, and you were seeking a personal injury action in Kentucky, Kentucky would still say, okay, based upon the final aspect of our borrowing statute, we're still going to apply the rules of procedure from Tennessee. Whereas on the flip side, if, for example, we were in Florida, and we said, okay, well, we had one part of an action that occurred here, but we said for whatever reason, Florida has the most significant relationship, then we would apply the rules of procedure in Florida despite part of our legal injury occurring in another forum. So now we're going to talk about forum non-conveniens. I always pronounce this incorrectly, so do not laugh at me for that purpose. We're going to talk about forum non-se. So what is this legal principle? So this principle rests upon the idea that a judge may decide that even if a judge determines that they have jurisdiction over a legal issue, they may, in the interest of justice or in the interest of preventing harassment to one of the parties to a legal action, they may still refuse to hear your legal matter just based upon grounds of convenience. Now, it is important to note that when we're talking about forum non-se issues, that the principle is harder to implement, or it's harder to argue when we have issues around specific venue statutes. So for the most part, most states, if they have a venue statute, they tend to have what we consider a broad general venue statute. So for that, we can sort of pursue forum non-se issues with ease. However, if a venue statute is quite specific, whether that is a federal or a state version, courts will often decline to entertain arguments around this concept because they believe that legislative interruption on grounds of jurisdiction and determination of venue trump equity principles as determined by a court. So when we're looking at the issue of forum non-se, we're going to look at private and public factors. So you will want to argue things like the ease of access to evidence, the ability to serve process with ease. You'll want to look at whether or not generally a case will be able to be implemented with less cost and more speed. And you also want to be able to show that by entertaining this legal action in a specific venue, that you are not attempting to vex, harass, or oppress the defendant by inflicting upon said defendant things like unnecessary expense or trouble. Now, they will also consider things public interest factors. They'll look at things like judicial calendars. They'll look at things like the availability of jurors in the event that you're seeking a jury trial. They'll look at the interest of having localized controversies decided at home. And of course, we get all of these factors from Gulf Oil Corp versus Gilbert. Now, Congress has codified the forum non-se provision at 28 U.S.C. section 1404, still applying the factors that we just discussed in the previous slide. And then, of course, the statute is quite simple. It talks about, for the convenience of parties and witnesses in the interest of justice, they may transfer a civil action to any other district or division, where, of course, things like jurisdictional and venue requirements can be met. So what is the big takeaway from the forum non-se discussion? The big takeaway is this, is that substantive law differences do not carry much, if any, weight in a consideration of the forum non-se discussion. So based upon this, if, for example, you are seeking to have a case moved to a different forum that has more favorable substantive law, as long as you can also argue that the additional forum is also more beneficial on grounds of judicial efficiency and procedural rules and things of that nature, you can get the side benefit of favorable substantive law with sort of a more efficient or favorable venue as well. You just have to be prepared to not just argue that the reason you are filing a motion for Form Non-C is because of a more favorable substantive law. It's another one of those areas that if you are form shopping for better substantive law, you just actually don't say it out loud. You want to make sure that you can also argue grounds of judicial efficiency. So people that have successfully argued these things argue things like backlogs on judicial calendars, cost of acquiring evidence, efficiencies around service of process. And this is an example of where the court said that merely showing that a change in substantive law that is less favorable to a non-moving party does not carry much weight in the consideration of a Form Non-C motion. And that's from the Supreme Court. And like I said, if it's good enough for the Supreme Court, it's good enough for me. Another thing to note is when you're form shopping, the plaintiff gets the presumption. If you represent the plaintiff or you are the plaintiff, you are in luck. Courts over and over and over again do not require a plaintiff to prove why a desired venue was chosen to overcome a presumption of appropriateness placed upon the plaintiff. Now, a few legal commentators believe that this presumption exists because of the pride of judges. For example, one judge wrote that a defendant challenging the plaintiff's chosen venue or forum when jurisdiction was appropriate was challenging the integrity and the impartiality of his court. Now let's talk about rational choice theory. So rational choice theory is used by many to argue that form shopping should not only be allowed, but should be encouraged. So rational choice theory says that the higher a plaintiff's expectation that a particular court will make a favorable court access decision, the more likely that plaintiff is to file a lawsuit in that court. Now, this typically means that the more opinions published or the more evidence produced by a court that tells a potential litigant that his or her claim is unlikely or is likely to succeed, the more likely a plaintiff is to file a complaint elsewhere or to file no legal action at all. Now, the calculations for rational choice theory are quite simple. Rational choice theory says that a plaintiff will file a claim if the expected value of the claim, which is the probability that the plaintiff will win, represented by P, times the amount of recovery, if the plaintiff wins, W, less court costs, C, is greater than 0. We call this the filing condition. So if P times W minus C is greater than 0, rational choice theory says that a plaintiff will file a legal claim. Now, rational choice theory also says that if given choices, if given the ability to form shop, a rational plaintiff will also file a claim in the legal system that maximizes P times W minus C, so that maximizes judicial outcome. So this has led many people to say, okay, well, if the true motivation behind the law is to ensure the best access to justice possible, then rational choice theory supports the promotion of forum shopping between states in all situations that do not involve the concerns laid out in Erie v. Tompkins. Or in other words, that rational choice theory supports the idea that forum shopping should be encouraged in situations where substantive law or associated administration of said substantive law of a state is not affected within the four corners of a state. Now, it's also important to note that supporters of rational choice theory say that if forum shopping is discouraged, that courts generally will suffer. If a potential plaintiff is unable to file a claim in the jurisdiction or forums where the expected net gain is the largest, then oftentimes the plaintiff will not file a claim at all. This leads many supporters to say, of the rational choice theory, to say that the same inequitable administration of the law that was desired to be prevented by Erie due to courts never hearing those very claims necessary to flesh out the murkier areas of the law, as is the role of the court to do. So in other words, they're saying that if administration of the law within a state by a state is a defining factor in why forum shopping is judged positively or negatively, that rational choice theory says, okay, well, if we don't encourage forum shopping, that we may encourage plaintiffs to not assert legal interest whatsoever via legal actions, and thus we may continue to not develop case law or to flesh out legal areas where confusion may exist or where things like ambiguity may exist. Another thing to consider is, does your state, when you are forum shopping, have a first to file rule? So first to file is very simple. A first to file rule allows a state or federal court to transfer, stay, or dismiss an action when a similar complaint has been filed in another court. Now, the excerpt that I referenced does reference federal courts. However, many a state court has mirrored the federal first file rule in application of their own state law in state courts. Now, first to file does have certain requirements. Number one, you have to show that if you have filed a legal action in one form and then subsequently in another form, you have to show that the legal actions are almost exact. You have to show that the parties are identical and that the legal issues raised in both legal actions in separate forms are the same. Now, it is also important to note that, as I was saying, 16 states have adopted some version of the federal first to file rule. Now, when we're dealing with first to file, it is important to note that first to file says that if we are looking, that a judge will not automatically dismiss the latest filed legal action if the judge attempts that the reason why we're filing multiple legal actions is to forum shop. So if, for example, you were going around and you would file three same legal actions in 3 separate forums in order to see which one will give you the most favorable outcome, judges frown upon this, and as a result, what they will typically do, instead of dismissing the later cases, they will simply stay the later cases until some version of outcome on the merits of the initially filed legal action has been determined. So now the fun conversation around the ethics of forum shopping. So the model rules may actually encourage forum shopping. As we know from the preamble to the model rules of professional conduct, one of the basic principles underlying the rules is a lawyer's obligation zealously to protect and pursue a client's legitimate interests within the bounds of the law. We also know that Model Rule 1.1 says that a lawyer shall provide competent representation to a client. They define competent representation as the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Under Model Rule 0.1, many a court has recognized that competent representation may encourage, if not require, a lawyer to forum shop in order to determine the best forum for the most favorable outcome for your client. Then, of course, we have Model Rule 3.1. 3.1 says a lawyer shall not bring or defend a proceeding unless there is a basis in law or fact for doing so that is not frivolous. This has been interpreted on both sides of the aisle, with people saying that forum shopping is a basis in fact that is not recognized as being frivolous. You are defending your client in a way that is designed to ensure a more favorable outcome based upon court structure and substantive law, and thus Model Rule 3.1 is not violated, but is in fact satisfied when an attorney forum shops. And then, of course, we have Comment 1 to Model Rule 3.1, which says that the advocate has a duty to use legal procedure for the fullest benefit of the client's cause, but also a duty not to abuse legal procedure. So Comment 2 then moves to say that an action is only frivolous if the lawyer is unable to make a good faith argument on the merits of the action taken. So this has led many a legal commentator and many a law professor to say that taken together, 3.1 and the rules noted above, appear to establish an ethical foundation necessary to support a lawyer engaging in forum shopping. Now, from my review of bar opinions on this matter, it appears that forum shopping was only improper under rules of legal ethics when the claim was frivolous, or when a lawyer did not provide any good faith rationale for why the lawyer chose one forum over another. Now, another thing to note is that courts do not appear to support sanctioning attorneys who forum shop. This is an example where a person brought a Rule 11 request for sanctions against an attorney who was forum shopping. Now, the interesting thing about this was that it was done in New York. Now, as we noted before, New York does not encourage, as a matter of public policy, forum shopping. However, here, the judge said, well, even in instances where we are dealing with the sort of unapproved practice of forum shopping, that forum shopping does not arise to the level of sort of poor behavior or unethical behavior that would give a judge grounds to provide sanctions for forum shopping. So that is the real extreme example. Now, there is one exception that I was able to find when we're talking about sanctions based upon forum shopping. Now, that is where a lawyer has dismissed a case to attract a more favorable forum. We have, for example, this Lex blog that's talking about an Eighth Circuit case where in the context of a class action settlement, and a lawyer went out and dismissed a case in order to seek a more favorable forum. Now, it should also be noted that when the individual dismissed their case to seek a more favorable forum, they did it in a way that lacked candor. The court ultimately said that because they did not provide the true basis for why they were seeking to dismiss their case and file subsequently in another forum, that they had engaged in an unethical and frivolous behavior under multiple violations of the rules of professional responsibility. This, of course, is that rule requiring lawyers to engage in candor with judges. Now, as I was saying before, that at least in the Eighth Circuit and the issues around that is that judges say that a lawyer has failed to provide candor if a case is voluntarily dismissed for forum shopping purposes without an explanation to the judge from the attorney representing the dismissing party, explaining that the purpose is for forum shopping. Now, we also run into an issue of the home forum exception for defendants. So sometimes defendants will file a motion for forum non-C when the defendant has been sued in the state in which the defendant resides. Now, this has sparked many ethical discussions by legal scholars who wonder what could be a more suitable forum than the one in which the plaintiff or the defendant lives. Now, this has led to an insurgence of complaints filed against attorneys for violation of Rule 3.2, which says that a lawyer shall make reasonable efforts to expedite litigation consistent with the interest of the client. As one commentator put it, the decision to invoke forum non-C as a means to attempt to have a case removed from the defendant's home forum amounts to little more than slowing the pace of litigation with no benefit to any party other than the attorneys involved who bill by the hour. Now, this ethical issue gets even murky when you see that courts never grant forum non-C motions by a defendant sued in his home forum. This is an excerpt from a case from where a judge has essentially said, I cannot fathom why a person would want to go out and would ever grant a forum non-C motion for a defendant who is sued at home. All right. Last but not least, some takeaways from this. Forum shopping via transfer of venue, the filing of legal actions in multiple forums concurrently and under forum non-C are valid. Forum shopping via motions to recuse or dismissing an action to file a subsequent action without notifying the judge as to why in another forum are likely invalid. You need to determine if you meet jurisdictional and venue requirements for a desired forum before shopping. You also need to be prepared to provide for the judge crystal clear, and this is and I'm putting quotations around crystal clear because that was a term used by a handful of judges, crystal clear evidence that you will meet the jurisdictional and venue requirements in your chosen forum. You also need to check if your desired forum has a borrowing statute. And if so, you need to understand, does the borrowing statute have exceptions based upon that sort of substantial relationship that Florida uses, or does it look at the final act version of a borrowing statute like Kentucky? And last but not least, as a reminder, Supreme Court jurisprudence only appears to discourage forum shopping when it infringes upon federalism. So that is when forum shopping attempts to use a federal court to interpret state law in a way that is different from how the state court up the block would do so. That is Erie in a nutshell. All right, everyone, that is all I have for you today. You have been great. I want to thank everyone for staying with me. I will provide you a follow-up email in the next, honestly, probably 2 or 3 days with the case law, with the statutory provisions that I use to conduct this session, and I will also provide you with larger versions of the graphs for subject matter and personal jurisdiction. So be on the lookout for that email. If you do not receive it by Friday, feel free to shoot me an email to support@fastcase.com. Once more, that is support@fastcase.com. Otherwise, enjoy your Wednesday, and thank you so much for coming out. We'll see you next Wednesday.